So I thought we would talk today about the role of Children's Council sort of in conjunction with the Children's Council in the case study we've been doing all week. Alicia, Jason, and Jonathan, three. And I have Carla, who represents Alicia. I don't see Kayon represented Jason. And Jonathan, you represent Jonathan, correct? Yes. And actually, everyone can weigh in on this because I think we finished sort of assuming our roles in the case and discussing what. And Rick had no problem assuming his role. Let's all sort of weigh in on the peculiar issues surrounding role of Children's Council, not only in general in children's cases, but in this particular case. So I mentioned before that what happened in the real case is, and I'm looking at the original dates here. So the original care and protection petition was filed on April 22nd. So counsel for the father and children were appointed and entered their appearances. So there was one attorney for the father, one attorney for all three children. The investigator, of course, was appointed as well. About a month later, well, it was more than a month, maybe a month or so, but in the interim was the not only the taking of the children on an emergency basis, the placement with Uncle Tony, the original SANE investigation that didn't go so well because the children pretty much didn't say anything. Then the also failed attempt at the district attorney's office for the children to be interviewed. And it was shortly after that, June 29th, that the new attorney, who was hired by Uncle Tony, entered his appearance with the court. And in this particular case, the court appointed guardian ad litem. But let's say that you were appointed, all of you, right, for the children. Obviously, you can converse, and you converse in different ways, right, with Alicia, with Jason, and with Jonathan. So when the Mass Rules of Professional Conduct as well as CPCF's rules use certain terms. For example, the child's preferences, eliciting child's preferences in a developmentally appropriate manner, maintaining a normal client-lawyer relationship if you can, arriving at some decision relative to the child's capacity to make, quote, adequately considered decisions. So let's start with Alicia. And suppose that you've interviewed Alicia. First of all, in interviewing Alicia, what sort of things would you talk to her about? What sort of things would you want to know about her? And then at some point, what kind of advice would you give her? And how would you arrive at kind of these decisions in terms of in what way would you represent her in the care protection case? So I know that Carla had Alicia as a client in the case study, so I'll start with you, but everyone else can weigh in too.
Well, I will definitely ask her what is her goal, what does she want. If she wants to go back to her father, or wants to be with somebody else. I don't know. I really don't know what else to ask her. The type of relationship that she has with her father and her brothers.
you're all thinking, I suppose, right? I mean, you've met her for the first time. So while that information the college has mentioned, absolutely, but what particular sort of groundwork do you lay out first? And again, it has to do with getting to the point where you can have a client-attorney relationship. Think about a client coming to you for the first time. What kind of information do you want first? Jonathan and then Sharon.
I'd say I would stress the fact, the confidentiality issue of everything she tells me would, to kind of accommodate her, make her feel comfortable. I can't tell anybody what she tells me. Everything's private. It's okay. Talk to me.
Advise her about attorney-client privilege.
Yep.
Okay, but even before you get kind of to that step, because this is a child client, what kinds of things do you have to determine about the child client? Sharon, what were you going to say?
I just explain, what my role is towards her, and trying to question to see if she really understood, why I was there.
Okay, again, so far all appropriate things that you need to get to. But you're meeting this child client for the very first time. All you know is her age, and maybe you've got the 51A report. Tika?
Maybe just talk to her, get to know her a little bit.
So how do you do that?
Just ask her about herself, what she likes to do, how she likes school, what she does at school, about
Sure.
her friends, things like that. Just so that she feels comfortable talking to you, and then you can kind of get the feel of how she is as a person as well.
Okay, all right. So you want to go kind of there first. At this point, again, you might have a report from the court. I'm sorry, you probably have a 51A, or at least what the 51A alleges, in your court appointment. You probably don't have much else at the very beginning. So, you need to know about this particular child client so that you can make a determination as to when you do give her the legal advice, can she make what's called an adequately considered decision, right? So school, how old are you, what do you like to do, what are your hobbies, who do you hang out with, and at some point you'll get to the sticky questions, right? Because, and as Jonathan said at some point, you'll also advise her, and Sharon did too, this is what I do and my role in this proceeding. It could be a child client that knows nothing about the legal system. It could be a child client that knows maybe a lot about the legal system and maybe even distrusts lawyers. Again, it's eliciting the child's preferences, as you say, and I'm reading right from now the portion of the CPCS, the Committee for Public Counsel has in Massachusetts has performance standards for all attorneys, and 1.6 talks about determining and advocating a child client's position, and that was really a tough issue in this case, that determining and then advocating Alicia and Jason and Jonathan's, what their position in this case should be. So, you have the conversation, maybe you have more than one conversation, and here's the other thing. If you read the article that I wrote as well, there were some cases cited. Georgette was an S3C case as well as Erica, and the cases talked about attorneys representing multiple parties, especially in children's cases. And that was pretty much around the time that the Mass Rule of Professional Conduct rule was changed and amended as well, to kind of recognize that you might have to deal as an attorney with a client that has what they call a diminished capacity, whether that client is, a child or say an elderly client or mentally ill client or whatnot. But in those days, when the care and protection petitions, were filed in the court and attorneys were appointed, they always just appointed one attorney for all the children. So again, cases came before the court, issues came before, relative to lots of these cases where you could have children with differing interest. Some needing protection from the parent, some, not being able to articulate their preferences, some wanting, to stay in the home regardless of that the parent might have been an unfit parent, yet the child has the ability and maturity to make the adequately considered decision. So what happened was, getting back to the case, no, hold on a second, before I get back to the case and what happened. So you're talking to Alicia, let's say even you're talking to Jason, another attorney, gets appointed, or it's the same attorney. And so you've determined that you found out about them, and it's true. They do very well in school, they're mature, they kind of stick together as a family, they look out for each other. And they even say to you, even if the allegations that the state is making against my dad were true, we still would want to stay at home and be a family, and we want you to advocate against the state. So, you're hearing this from your client, who's a child, 12.5 and 9.5. But you have feelings about it, right? What do you do? And what kind of problems, ethical, moral, etc., are you facing at that point in trying to determine and what position to advocate to the court? Yeah, that's right.
I mean, I think the most obvious one is that if the allegations were true and they still want to go back, obviously you don't want them to go back there. I don't think any adult would want them to go back into a place where they were getting abused, whether it was physically, sexually, emotionally. It just wouldn't be in their best interest. But I do think that they're entitled to, they have a voice, and they, I've never been in that situation, but obviously regardless, they still love their dad, and that should be known, and they deserve to be able to say that out loud regardless of any of the allegations. But I mean, I'm not sure how comfortable I'd be advocating that they should go back. I mean, but over time, maybe, but I'm not really sure what I would say to them on the spot if they just said, oh yeah, I want to go back.
And they say, I want to go back and I need you to advocate that position to the court. Meaning you're an opposing party to DCF, if that's the case. Nick?
I mean, I think at the end of the day, it doesn't really matter how the attorney feels, because when I was reading your article, and it was about the champion against the advocate or whatever, it's really just you're supposed to do what your client had asked you to do. And if you want the child to have a voice, you're looking at the...
Slow down for a second, because you said, very important, you said you're supposed to do what your client, did you say tells you to do?
Well, when I was reading 1.14, you're supposed to treat them as, as a regular client, like an adult per se, if that's possible. But
if that's possible, so what does that mean, if that's possible?
If they want to go home to their dad, although you yourself have feelings about it, you have to be able to advocate for them, because that's what they want and that's what they expect you to do for them.
John?
think it's it's almost a balancing test or a dilemma between what your client wants, if you happen to be representing a juvenile, and what's in the best interest of the juvenile. So you've got to
Yeah.
kind of come to that happy medium between the two.
Well, that is the dilemma, but do you, as an attorney, come to a happy medium, as Jonathan said? I think, I don't know if it was for Jean-Paul or Sharon.
I was just gonna say, I think that the best is to be the guardian ad litem.
What
because
about the guardian ad litem?
They do what's in the best interest of the child, not necessarily.
Okay, but at the beginning of every care and protection case, the only attorneys you've got is the DCF attorney, parents, maybe more than one parent's attorney, and child's attorney.
Right.
So you don't have a guardian ad litem. So here you are talking to Alicia and Jason, and you're like, oh my God, I know something happened. They, at least at this point, haven't told me, or have told me nothing has happened, and we understand what these proceedings are all about. You've advised us, but this is what we want you to do. So you've got, as Jonathan said, the dilemma is right now in you, yet you're feeling that you probably, as an advocate for the child, you probably need to present the child's preferences, because they seem to be, again, smart, mature, etc., that they, in spite of the alleged abuse, they've made an adequately considered decision in terms of how to direct their strategy. So how do you get it? How do you get the court to consider the best interest of the child? Jean-Paul?
I think that's I'll go with what she just mentioned, that if you think that it's not, that is from the article, maybe the rule of the CPC, the rule 1.6. If you think that it's not in the best interest, but if that is the position of your client, and you're against that position, you still advocate for your client, but at the same time ask the court to appoint a guardian ad litem. But also, there's a footnote of the other article that you authored with the judge that says that to the question you asked earlier about the moral, if you're going to do something that is against your own belief, your moral belief, if you think that is also a position that your client wants to take, and that position is against, you think she's competent.
So, wait, are you saying that the child's attorney is actually going to ask the court to appoint a guardian ad litem?
In one of the recommendations, if she's competent, and you think she is competent to make that decision, not to determine what is best for her, but she's competent to know.
She's competent to direct her trial strategy,
Right.
because you've determined she can make an adequately considered decision. Yet you feel that someone should be in there for best interest, that it can't be you.
And then they make a recommendation.
Are you saying that you can file a motion or in any way ask the court to appoint a GAL?
That's
What's the problem with that?
That's what I'm saying. But
Rick, what's the problem?
I'm thinking you have to show that she has a diminished capacity. And
No, in our instance, we're saying that there's no diminished capacity, that this is a child, these two are children, that can make an adequately considered decision, that they're not only mature, maybe even mature beyond their years, in terms of whatever expertise you have to evaluate the development of children. They've directed you to act in this manner, and you know that you have to, according to both the rules of professional conduct as well as Committee for Public Counsel. But you also feel that the court should also be hearing from someone that would be in there for their best interest. So there's no GAL yet at this point. But the question is, and the problem becomes, can you, child's attorney, ask for a GAL?
I thought so. I thought you could.
Okay, so pretend you're asking me for a GAL. I'm the court. I'm the judge.
I'm asking you to appoint a GL
Why?
to investigate.
Why, counsel?
To help the court determine what is in the best interest of the child.
Why do I need to do that, counsel?
Because I don't think the child is mature and competent to understand what she wants to do with this case.
So why do we need a GAL?
But because the child, the counsel is not convinced that the child's recommendation or the counsel.
You just violated attorney-client privilege. In order for him to convince the court that there's a need for a guardian ad litem, right? And again, it's not an incompetent child situation, that's different. Okay? It's a child that's talked to him and made decisions as to what he or she wants to do, yet he, again, feels that dilemma, wants the court to appoint guardian ad litem. There's nothing wrong with wanting the court to do it, but in wanting the court to do it and asking it, there's sort of a red flag that you're now sort of disclosing to the court that you may be disclosing either things the child has told you or things you've learned as a consequence of the attorney-client relationship, that you feel that the child is, maybe not unsafe, but, that there's some issue relative to his or her best interests. Right?
I was going to say, we will probably suggest the guardian ad litem be introduced to the child to help the child understand.
I know, but here's the problem. Unless the court or someone else does that for you, if you want a GAL and you're the child's counsel, you have to be very careful. In fact, the CPCS rules mention it in one of the notes somewhere, that requesting a GAL in such cases is actually contrary to the rules of professional conduct.
Can I say?
Yeah.
In some of the footnotes on page 22 of the article, where they said one of the few things you can do as an attorney who's doing exactly what the question is, there are a number of things, I think 4 things you can do. And the third is inform the court of the child's express preferences and request the appointment of a guardian ad litem, next friend, to direct counsel.
So in what instance would you be able to do that and not violate your...
I think the risk...
And I think you're talking about the situations where the child is really not able to make an adequately considered decision. And if you think that pursuing the child's preferences would put the child at risk. See, the bottom line is that you hope that in the situation where if you ask for a GAL, especially when it looks like, it sounds like it is that your child is making the decisions, wants you to act in this way, and yet you're reporting to the court that there's some red flag here, you may end up violating and saying something about that child to the court that maybe you shouldn't say. In our case, and remember I said to you that the judge appointed me. The judge appointed me. So he knew, even without sort of like, if this was at the inception of the case, he caught the red flag before anybody said it to him. Because he had, first of all, the first appointed counsel for the child within a month was fired, and new counsel files an appearance for all 3 children, advocating return to father, and it's a heated, child sexual abuse issue. So that judge knew, and most juvenile court judges are truly like legal specialists in the area, and you hope that you don't have to bring that red flag to the court, because to do so you might have to disclose information about your client that would violate, again, ethical rules. And again, this only goes to the child client who's competent. If the child client is incompetent, and that's another issue, and we'll discuss that with regard to Jonathan. Yeah.
Just a quick question. Would competence fall under the category for somebody who has been abused so much that they want to go back to the abusive parent or whatever, but it's totally not the right thing to do, but they, in their mind, regardless of how bad the abuse is, they just keep wanting to go home, they want to go home, they want to go home. Would that be an incompetence in some way because they're unable to, you understand what I'm saying?
Yes, I do, and also, the child's express, the adequately considered decision may apply in some circumstances and not in others. The express preferences, again, may apply in some circumstances and not in others. The child may understand some things, but not other things. The CPCS rules also talk about, in terms of you as an attorney for a child who may be at different levels of development and whatnot, stress that we as attorneys, we're not only advocates, but we're also advisors and counselors. So if you could have the time to develop the relationship with that child, and make sure that the child gets, for example, professional help, depending on what what the issue is, emotional, sexual, etc., that the child may end up disclosing and thinking about other courses relative to the case. So for example, they're already in DCF custody, and they're placed at least temporarily with someone. They may say to you at the very first instance, yes, I want to go. All of these children want to go home. I want to go home. I want to go home. Okay, let's talk about that. We'll talk about that. Let's see. Let's get you here to talk to this person, talk to that person. Sometimes time ends up sort of helping the situation. If in the end the child is still expressing, a preference that is a return again to a home that is, well, I'll just say, because the rules talk about marginally unfit, whatever that means, but it still is in Massachusetts a client-directed model. And it sounds so unpopular to people, so displeasing, especially because we're, all about justice and helping people and whatnot. But the bottom line is, if this, and Elizabeth said you used the term voice before, and I like that you did that because it kind of goes back to the beginning of our classes when we looked at Gall and whatnot. If the court doesn't get to hear this very unpopular voice, I want to go back to my abusive father, then the court hasn't really heard from everyone, right? And that goes to the theme of that article that, you're not, as much as you want to be the champion, you really can't be. Again, you can't be if you've done an adequate job of advising your client, and that involves not just sitting and talking with your client, maybe again, making sure that your client gets the therapy, etc., that he or she needs. It could be that she could come back to another viewpoint at some point in time. That didn't happen during the course of this care and protection case, but it happened in the end. I'll tell you shortly. John Paul?
Yeah, I'm not sure whether you answered that question, but I was busy. I know that I read it somewhere. Well, the two things you can attempt to do that include the appointment. The appointment can happen, but only if you discuss.
So what can happen? I'm sorry.
The appointment you can still ask the appointment of guardian ad litem only when you discuss this with the child. You need to discuss the child, and therefore there's no violation of the ethical rule of the client confidentiality. And also you can attempt to withdraw if it's against something that you're.
Did you say withdraw?
Withdraw.
Well, that kind of stinks too, because you withdraw and then the next attorney is stuck in the same boat as you, and really what have you done to sort of
It's an
help
option
this
they're
situation?
giving you as an attorney, again, it's.
But no problem you asking for a GAL if truly your client has the diminished capacity. It's if your client doesn't have the diminished capacity and you ask for a GAL, you're going to get involved in a conversation with the court or whoever, where you're going to end up disclosing confidences that you.
So do you
that
insist that
should.
this you should be, that's only when you are incompetent?
When your client has, in fact, it's, so you have rule 1.14 that I put on the board, the performance, rules of professional conduct in Massachusetts. A talks about maintaining, that 1.14A says that even when your client has perhaps a diminished capacity, you want to maintain as much as you can a normal client-lawyer relationship. But if your client's diminished capacity has come sort of, puts that client at risk, okay, at risk, physical, emotional, etc., then you can take some kind of protective action. So, because what are you doing? You're protecting your client who has diminished capacity. Your client that doesn't have diminished capacity, the mature child, has the right for you to, has the right to direct their own legal course of action.
But the lawyer here, I think again, in the article you co-authored with the judge.
And wait, let me just interrupt for one moment. And in the course of children's lawyers, this is not, this is kind of new. When I say kind of new, maybe in the past 20 years, when children's lawyers were first appointed, following the juvenile court and Galt and all of that, for the most part, they were champions and they were best interest kinds of professionals. In fact, Massachusetts is very much in the lead in terms of client-directed, follow the child's preferences. If the child can, has the ability and maturity, etc., to make certain preferences, even if they go against what looks like their best interest. That's not your job as the child's lawyer to make. Some states have a hybrid kind of thing, best interest and client-directed. Some states have a guardian ad litem type of approach as well. So there's ABA standards that I mentioned as well, and National Association of Council for Children. There's all the International Convention on the Rights of the Child. But again, if you're practicing in Massachusetts, first of all, you have to follow the rules of professional conduct, or else you could get in big trouble with BBO. And secondly, if you accept these cases and get trained by the Committee for Public Counsel, you have to follow their rules, which I've given you the performance standards. Which, by the way, for example, Jonathan, who's 3, is a different story. Now, first of all, the committee talks about visiting your child client. Even if your child client is 2 days old, at a minimum every 3 months. Observing them in their environment, talking to people that they're dealing with, playing with them, again, all of that developmentally appropriate stuff. But you're doing something different because obviously that child client isn't like Alicia and Jason, who can make the adequately considered decision. So Jonathan, when you represented Jonathan in our little case study, did you go through in your mind how, you arrived at what your position at trial should be?
I looked at what the best interest of the child would be. I think I also speculated what he would want had he been older. based on like the facts that were given in the case.
What did you speculate? I'm sorry.
What he would want.
What he would want, if what?
If he wanted to go back to his father.
What he would want if
He was old enough to make the decision.
Exactly, and that's the substituted judgment approach. The first approach that Jonathan mentioned, he could not do, again, in Massachusetts as attorney for the child. He could not tell the court, well, I'm representing the child's best interest because the child's only 3. Well, counsel, you're not the GAL, you represent the child. Oh yeah, I represent the child. So what's your position? Well, if Jonathan were able to make an adequately considered decision, Jonathan would actually want to be protected from the, what was going on in the home. And courts in Massachusetts have held that you don't have to wait for disaster to happen, et cetera, et cetera. It's likely that as this child got older, he would also be sexually abused by Lee. Therefore, my position is blah, blah, blah. So his position could be diametrically opposed to the other attorney's position. And that's the reason why there should be separate attorneys in many instances for child 1, child 2, child 3, child 4, whatever. Sharon?
I just have a question about this whole process.
Yeah.
Where the court knows that the attorney for the children are to represent them zealously, which is not always in their best interest. And the whole reason that they're in court is to protect them.
Wait, the whole reason who's in court is to protect?
The whole reason that the case comes about is because there's a question of protection for the children. So
Because the statutory process is care and protection of children, you're saying? Yeah.
So my question is, why don't they automatically appoint the guardian ad litem?
That's a very good question. And part of it has to do with finances.
That way it would alleviate
Exactly.
an attorney trying to break confidence.
Absolutely, yeah. Because you do need somebody, because DCF, the state, sure, the state is strength and encourage family life, want to protect children, et cetera, but they're truly not a best interest advocate. Neither is, again, either parent's attorney, neither should children's attorneys be. So that I totally agree with you, is there should be a guardian ad litem whenever the issue of best interest comes. And sometimes it happens after cases, in this particular case, it was at the beginning of the case, but sometimes it comes up during the course of proceedings and a guardian ad litem gets appointed. And courts have to be careful too, what they're appointing the guardian ad litem for. So in some cases, it might be for an investigation that's similar to the court investigator. Sometimes it might be just to articulate a position. Sometimes it might be to determine competency. So you might have a guardian ad litem that's more like a psych professional than a lawyer. So many, many reasons. In this context, we're talking about the guardian ad litem, just that has experience in making a recommendation and articulating about the best interest of children. So that's the, core of the debate that still goes on as to, role of children's counsel, especially in, contested abuse, neglect, kinds of cases. And again, when the child doesn't have the capacity to make the adequately considered decision, then you're still not doing best interest, but you're substituting your judgment. Again, I go back to that if Alicia and Jason, at that point, today, their attorney, yes, would certainly have to abide by these rules, but remembering that we're also advisors, we're also counselors, and the attorney might be more versed in the dynamics of either domestic violence, child sexual abuse, emotional abuse, whatever, could make sure that their client is also getting the professional help so that perhaps the client may end up disclosing or, arriving at a different sort of decision. Or sometimes the children just don't want to have to make the choice, right? I don't want to be the one that's responsible for Dad going to jail even though he hurt me. So I don't want to have to say it. You do it for me. And I get clients like that as well. So not to mistake that they don't have the capacity to express the preference. They don't want to express the preference because of, guilt and, all kinds of other issues as well. But if you remember nothing else, remember that, we're, again, no matter how young the child is, we're client-directed model. And you have to figure out in any way that you can what that child client wants and express those preferences to the court.
I just have a question. When you're determining competency for your client, if you know, it's like a classic symptom for abusers, they want to be pleasers to the abuser, and they're saying, I want to go back. Can you use that to say?
And that's why, and that's how, I think in many cases that's where time and some kind of professional help as well can remedy a situation like that, because that's exactly what happened here. I mean, Alicia and Jason, first of all, he wasn't their biological father. That doesn't mean that you can't also, have a parent-child relationship, of course. But the longer that they, and they were actually removed from relatives at the end of the parent protection trial. And so that the longer that they were in a protected foster home, the more that it gave them time to heal and to start to disclose. All the time that they were going through the camp protection proceedings and getting visitation and seeing their father and whatnot, they were doing exactly that. No matter what, even if it really happened, we don't care, we want to stay with Dad, and blah, blah, blah. That began to change the more they became removed from him. Then the more they sort of stayed insulated and protected. So sometimes, many times, time is what helps. Now, the interesting thing with this, even in those days, this case went to trial so fast, and the camp protection case actually went to trial before the criminal case. So the camp protection case went to trial like that fall. I think we concluded in the spring, but even that was within a year, when those cases kind of sometimes languish for years, and even today, it wouldn't be heard for 15 months. The camp protection case went to trial very fast. The evidence stunk, because you saw what it was. It was nothing. It was the police officer investigator attempting, to use hearsay, and all kinds of arguments were made against that particular evidence. At first, the judge took it in because he thought it was going to be a fresh complaint. Then he heard that Alicia and Jason weren't going to testify. There actually was an expert, but the expert was the father's and the children's expert, who was a psych person that was really not versed in child sexual abuse, though he was versed in child trauma. And when he tested the kids, they did great, but there wasn't even sort of any, forget any evidence of sexual abuse. There was no evidence of their mother's, the trauma surrounding their mother's death. So his kind of report meant nothing, really. There was the court-appointed investigator who testified and submitted a report. There was the admissions of Lee, the vague admissions. So all of that information that we talked about before that legally didn't really amount to clear and convincing evidence of current parental fitness. The judge decided that they did. Because again, in his mind, he knew something happened. He knew he was going to be taken upstairs for it, but he adjudicated the children in need of care and protection, had them immediately, removed. I don't know if it was immediate, but they were removed to a foster home. Altogether, all three, which was really, again, almost unheard of for usually, very young and then the older preteens and teens. And it was in that home that they were there for a while. In the meantime, this criminal case had not gone to trial yet. They were there for a while. They started to talk to the foster mother about what really happened. They ended up testifying against their father in the criminal case. And then he actually got an on and after because they, where do they come from? What southern state? I forget, it's in your packet. But he had, so he's, time and time because the sexual abuse started down there. The interesting thing was, I didn't go to the criminal trial, but I remember that his attorney telling me that the children didn't really, they testified against him, but they did not make good witnesses. Understandable, because here you have, and it's Massachusetts, confrontation. They had to be in the courtroom, he had to see them, but yet the court did, find that the criminal standard or beyond a reasonable doubt, was met, and he was, found guilty of rape and whatnot and all that. But they weren't very good, even when, again, they came sort of full circle and ended up testifying against their father. And again, we talk about the trauma that child victims, especially in cases like this, have, because they get traumatized first by the abuser, and then they're traumatized by the system. That's the reason for the 233, 81, 82 and 83 statute, but it does only apply to children under 10. You guys talked about competency. You have to make sure that that child witness is also competent to testify. Some very young child witnesses are competent to testify, so it depends on, I think of what a witness, how is a witness competent? Does that witness have the ability to, remember what he or she has observed and heard? So it's all about what you've been in and heard and saw and was done to and so forth. And can, in a sequential way, testify about those actual events. So some very young children can do it. Some older children can do it, but maybe not do it as well because maybe they're, have many more issues in terms of the emotional stuff that's going on. Oh yeah, so after the camp protection case was over, because the judge definitely made a legal error. So I can't remember who it was, but it was probably, well, I think it was both. Father's attorney and children's attorney actually filed an appeal, and there was an appeal in the appeals court, which in the end was vacated as the criminal case progressed because they didn't obviously end up pushing the appeal after that. But if it was just the appeal of the care and protection case, that judge would have been reversed. Again, because the evidence wasn't there to support his findings that amounted to clear and convincing evidence of the parents' unfitness. There was also a question of the mother's accident. I guess she drove off a bridge. And there was a time, it was around the time when Alicia was living with her, there was a question as to why and in what context that happened, that mother may have actually found out about the sexual abuse, why she just ended up with Alicia, not Jason. I never found out.
So were they separated at the time?
They were, but it was unclear as to how long and why Jason, why did she grab Jason when she left, only Alicia. Yeah,
I'm just curious, how much time did he serve, or is he still serving?
well, like 60 years or something. I mean,
So,
it was
okay.
time and on and after, whatever he got from Massachusetts and whatever he got from down there.
And my other question was, when they...
And there's something, go ahead, ask your question. I just remembered something about him when you said that. Go ahead.
Oh, just quickly, with regard to the foster homes, the ones that they're first placed in, not just with them, but with any care and protection case, do they often get to stay with that first family?
Well, this is
or-
interesting too, because, when you look at the regulations, so there are different families that are approved and for the most part, a lot of them are temporary foster homes. Remember, we talked about it's a contractual relationship that you have with the state. Some go through and want to ultimately adopt kids. And I can't remember, but at some point, this family became approved for adoption, which was just like, it was just luck or something crazy that number one, all three ended up together, and they ended up in a home that actually did adopt them. Whereas many children, kind of languish in foster care in one foster home after another, after another, after another. So that didn't happen in this case. And when we were talking about profiles before, if I could just describe Mr. Lee, he was tall, wore like like nice sweaters and loafers and everything matched, kind of like Nick and I'm kidding. But it's very, there's no real profile, when you think of a perpetrator, a batterer, a child predator, etc. There's really no real profile. All walks of life, all kinds of personalities, all kinds of people. And again, some are a result of some inter-family kind of issues. Some are not inter-family, but child abuse, by a stranger. Some are a result of, sickness, illness, psychopath, sociopath, etc. Some are just crimes. And we've gone through in the U.S. different ways of looking by the professionals at sexual abuse. Is it sickness? Is it crime? We keep coming back and forth on it. So can you imagine? I mean, it's so convoluted and so complicated that it needs so many more professionals involved. That's I mentioned in that other article I wrote with Nora that you as child's counselor, you don't have the tools really to make all these determinations. The best you can do is to get them to the professionals that would understand the dynamics and see if there's anything that they can do. Because we're just lawyers. We're just, we learn as much as we can about children if we're lawyers for children, but we're not sociologists, we're not scientists, we're not doctors. Jump on.
Now, are you aware of any recent changes in adoption, the rule, or maybe because there is a schedule, there is a case that it was trying to schedule for permanency, and
A case, a care and protection permanency, the 29B?
Yes.
Okay.
I think, I'm not sure whether it's 29B,
Well,
but
what court were you in?
it's juvenile.
Okay, yeah, it was probably a 29B permanency hearing.
Yeah, and actually they mentioned schedule for B, which is, I think, I asked the attorney and said it's a last pre-trial for, last pre-trial before they get to trial for permanency. for.
Say this again, you're confusing me, because at first I just thought you meant the review hearings afterwards, but you're talking about
Yes, they're
pre-trial.
scheduling for the last review, last hearing on that case.
Wait, is the child older? Are you talking about like a 17-year-old?
No, they're
No.
not. I didn't see them because the case was continuing.
Because first of all, the 29Bs, the hearings that are held every year after care and protection is over, we have this thing
Oh, no.
called aging out, kids aging out of foster care. Okay, it's not
No,
that.
that's
okay.
not that. That's actually the B they said was, I asked, it was a court that they told me it's just because it's the last pre-trial before they go to trial for permanency. And they said the rule that just changed. So I'm not sure whether it's new or whether it's the
They
same
could be
rule.
just talking about the care protection case where the department changed the goal to permanency to adoption. And
Because
it's the pre-trial, which issues are going to be on the table for the trial, who's going to testify, that sort of thing.
the attorney was because they said if the rule hasn't changed, it would be the schedule would be a little, they scheduled for June, and they said it would be maybe next month, would be quicker. But this time they said it's going to be June because the rule changed for adoption.
It could be the juvenile court rules, so each court also has their own rules that have to do with advancing of cases for trial and whatnot, and they have different time standards. So it could be that. I have to know more about it.
That's it.
So next week, we're going to do medical neglect all week. But if you could, for Tuesday, read the last case first, Cobble, because we're going to conduct this administrative hearing first. The IFA case that's in the materials, I also emailed it to you. So it's the very last case in your packet under medical neglect, Cobble versus DSS. The reason why you're reading Cobble first is Cobble, to understand the administrative hearing procedure that we're going to do for Tuesday, Cobble is the leading case, if not the only case, that went to the agency on the appeal of a 51B support decision. So I'm going to assign some roles for at least the first hearing. And I'm going to need somebody to play the father, the mother, the school nurse, the DCF worker, and the English teacher. And we're going to do that on Tuesday, and then on Thursday we're going to do the Superior Court argument, and that's what I'm going to need lawyers, and then going back and reading the cases so that you can make, an argument on the cases. So I don't know who has preferences to play a party on Tuesday or to be a lawyer for Thursday.
School nurse.
School nurse? Nick wants to be school nurse. All right. Okay.
Kidding. No, that works just fine.
Anybody else have a preference for those roles that I just mentioned? Sorry, I've already got the nurse. I need the mother, the father, the DCF worker, the English teacher.
I'll be the English teacher.
Okay. Leon is the English teacher. Okay. DCF worker, mother, father.
I'll be the father.
Jonathan?
Is that father of Jamil?
Yep. Need the mother, DCF worker.
I'll be the DCF.
Oh, no!
Always trying to be DCF. She can be DCF, that's fine. I can be the mom, that's okay.
Okay, Elizabeth is the mom. So, Sharon, you're the one whose investigation was supported, you're the one who supported the 51A. You did the 51B investigation, and so pretty much we would be starting with your kind of summary of the case and whatnot, and the decision of the hearing officer, and I'll play the hearing officer if anybody wants to chime in with me, they can, is whether that decision should be overturned or not. So it's an agency hearing, that's all it is, more informal than a court hearing, but still hearing from different sides, and the standard is mentioned in the Cobble case. So for Thursday, and you don't have to tell me now, but I'll be looking for attorneys for the department, attorneys for the parents, for the Thursday kind of hearing that we're gonna do. I don't know if we're gonna get to the third part, temporary custody hearing. I always think we're gonna have time, but we may not. Any questions? All right.
I have a question.
Yes.
I saw they recommend that a garden item be present during the council be present during the garden ad litem investigation when meeting the mother or the families, but some do not. Is it just
When you say some do, who recommends this?
I think it's some of the notes. It says it's best that it's always good when the attorney is present to make sure that the attorney, the mother actually doesn't, or whoever you are representing, doesn't reveal something that can backfire because you.
You can always ask to be,
Taken out.
present as counsel for, mother, father,
So what are
child.
the risks when
Yeah.
they meet without the counsel? Because if it's not required that they be there, and
I know.
and you reveal something.
And so many times attorneys don't get involved in everything that they should. For example, like the foster care hearings, parties just go in, without counsel, as you said. You get appointed, the day you get appointed, you should be all around thinking of that client's legal repercussions. Not only the day when they're actually in the courthouse, but so I totally agree with you, but I don't know how you police it.
It's recommended, but it's not.
Exactly, yeah. All right,